Hi everyone. So today I come with an interesting case which is about Getty Images versus Stability AI. So now Getty Images is basically a licensed photographer who has generated or who has basically a number of photographs, and Stability AI is basically a company which comes up with generated AI images. So now the Getty Images filed a case against Stability AI because they felt that Stability AI, which has these trained AI models, especially Stable Diffusion, has come up with mainly AI generated outputs which are infringing its images. So this was a case which began, or which was basically decided on the 4th of November 2025 in the High Court of UK. So now this has a lot of complexities and a lot of legal issues. One is it's got to do with copyright infringement. Secondly, it's got to do with trademark infringement. In fact, under copyright itself, it's got to do with primary copyright infringement and secondary copyright infringement. There is a trademark infringement, and then there is passing off as well. So now the main focus here is that Getty Images is basically their main claim or their main grievance or complaint is that Stability AI, which has created Stable Diffusion, is being trained, or that particular AI model is being trained on the images which have been created by Getty Images. So once it has been trained, they believe that although also the watermark which has been associated with Getty Images is basically being used or has been put by Stability AI on the or by Stable Diffusion on their own images. So this basically has led to trademark infringing. Moreover, Getty Images also felt that Stability AI is storing and distributing, training, storing and distributing copies of these images which or data sets on which Stable Diffusion has been trained within the territory of UK. And also it has led to a lot of brand dilution and brand confusion. So Getty Images has a reputation within the territory of UK, but because of all this sort of copyright infringement, Getty Images has started believing that Stable Diffusion, and mainly the company Stability AI, has given rise to, as a result of this generated outputs, has given rise to a lot of confusion regarding the brand, and has also led to passing off, apart from trademark infringement and copyright infringement. Now there are several arguments which have been put forth by Stability AI. So what Stability AI has to say with regard to this particular issue is that one is when the images are basically imported into a particular territory, they cannot qualify for primary copyright infringement. Secondly, if the training does not happen within the territory of UK, again it cannot qualify for copyright infringement. And it doesn't have visual copies of the Getty Images which are being stored or distributed for commercial purposes within the territory of UK. It has no evidence or it has no history of these visual images which have been stored as data sets, and it believes, Stability AI believes, that there is evidence or historical evidence to show that there is no storage of such copies, and it is basically already trained. The AI model has already trained itself by looking at the output image. It's been trained by looking at a number of data sets, and after training it on these data sets, it has generated its own outputs, and these outputs have been basically generated and released in the public domain. So there is no case of infringement at all. But the court agreed with stability AI in this particular case and agreed that the model is basically trained on statistical parameters, and the model is basically being trained on weights. The model learned weights, and also it has not stored any visual copies, and also it has not trained its AI model within the territory of UK. It has so then there is no clear case of copyright infringement that is happening. But however, when it came to the trademark allegations, the UK High Court felt that some amount of relaxation or some amount of strong contention which has been put up by Getty Images should be given some importance and validation, and should be acknowledged, because the watermark that is there, it has not been completely erased from the images which have been produced or generated by the AI machine, that is Stable Diffusion. So now, why has this happened? So this they have failed to do. In certain images which they have processed in the past, they have not done proper filtering of those images, as a result of which the watermark continues to exist. So now, because the watermark continues to exist, a person who is viewing a particular some photos from Getty Images and some photos from Stable Diffusion, they are seeing some similarity. So when they see some similarity, if not even a striking similarity, there is a chance of confusion. So there is a chance of confusion leading to brand dilution, or leading to some kind of loss of commercial revenue for Getty Images. So in that sense, there could be a slight trademark infringement and to a certain extent passing off. So this is the extent to which infringement can go. But with regard to primary copyright infringement or secondary copyright infringement, since the UK High Court has no jurisdiction to deal with this matter, because those images were not trained or stored or distributed within the territory or the limits and bounds of the territory of UK, one cannot really challenge the Getty Images, or one cannot challenge the Getty Images cannot challenge Stability AI, saying that you have actually stolen my images. You have used enormous amount of data sets which are my images to train your model, because that has not been the case. They have produced their own visuals, they have produced their own imagery through creative mapping, through their own research, through their own acquisition of information, and then they have probably released it. So there is no evidence to show that they have stolen or borrowed the images, they are trying to breach or violate the laws, or they are trying to grab the market which has already been created for Getty Images. So when no such strong evidence is there to support this belief, and the statistical parameters on which these AI models are trained are completely different, how can we bring about a copyright infringement claim? And for copyright, originality is an utmost important parameter. Idea is not something that is protected, but expression is. So when the expression that gets across to the public viewers, or an aesthetic appeal, or something which is original, grabs or draws the public attention, how can we sort of even get to brand confusion? Or the court agrees that there could be some amount of brand confusion, but calling it copyright infringement is really getting too far. So in this particular case, copyright infringement has been completely gotten rid of, and relief has been provided only to the extent of trademark infringement and passing off. So this is a very interesting case. So you can read about it by get some insights about it by reading the entire case. I have given a case brief, or a very, very brief insight into how this case actually played out in the UK High Court, and the arguments put forth by both the parties regarding the infringement parts. So you can read more deeply into this case, you can delve deep, and you can build your own insights and come back to me with comments and queries, and I'll be very happy to answer them. So I have done my research on them, so we can probably collaborate and sort of discuss the research findings. So that's it for today. Thank you.